Now let's say you got the hearing scheduled, and not what you wanted to do, but ultimately, at some point it has to happen. You have to move the case along. So they're going to schedule a hearing. Now let's say that you really are going to go to this. Now I'll tell you, a lot of times I don't even go to these things. Usually, because I know that they're going to produce the documents that they have. Usually even before the hearing, they've sent to me the things that I complained about, the acceleration notice, the assignment. And so I know I'm going to lose anyway. And so very often we'll talk a day or two before the hearing, and I'll agree to have my motion to dismiss denied, and then ask for 30 days to answer. So it gets me 30 more days from that day. But if you want to go forward with it and see how it goes, and they haven't complied, so let's say, and that's really the important thing, if they haven't sent you the documents that you complained about, there's no assignment, there's no endorsement, there's no acceleration notice. If they really didn't respond to you that way, then I think it's appropriate for you to go to the motion to dismiss hearing and see what happens. I can almost guarantee you, so I'm going to warn you ahead of time that you're probably going to lose. So don't feel bad if you lose, because you're probably going to lose. I'm probably going to lose if I go. Again, because they just don't like doing it on motions to dismiss. They should. They have a legal obligation to do that, but judges don't. They just would rather deal it substantively during the case. So just be prepared that you're going to lose, and you won't feel bad. And if you win, wonderful. Good for you. But let's talk about how this thing happens. So let's say that you're scheduled to be in court at 10:15 in the morning, and there's a hearing. The hearing could be one of two places. It could be either in a regular courtroom, or it could be in what we call the judge's chambers. Let's talk about the courtroom first. The courtroom's kind of like what you picture a courtroom. Usually the judge is sitting up on some high podium somewhere. There's a gate. There's tables up there with a podium in there where you would stand. So you go in there. It's very imposing. Whatever. Don't let it be that way. Probably they're going to have a whole bunch of these things handling at once, depending on the county that you're at. There may be 50 or 100 of these hearings going on at the same time. So you may be sitting there for a while. But just be prepared. So you're going to have your defenses, what we talked about. You're going to say, look, Judge, they don't have this, they don't have this. That's what you're going to say. So you go up. Typically, the party moving for the relief, in this case, you, because you said the motion to dismiss, is the one that goes first. And you say, the judge say, well, what's going on? Say, well, Judge, I filed a motion to dismiss because they didn't have this and they didn't have this. And they're going to have a chance to respond. And then the judge is going to rule one way or the other. That's kind of how it goes. Now, sometimes if you're pro se, they may let the plaintiff's counsel go first because they think they're going to get a more coherent description from them than from you. So if that happens, fine, whatever. And you got to know, and I just got to warn you about this, a lot of the times the attorneys that are going to be there are what we call contract attorneys. They're not the attorneys that work for the plaintiff's counsel. They're not the law firm that they hire local counsel to come into these attorneys. Because a lot of times, the attorneys are in some other part of the state, and they're not going to send one of their attorneys. They'll hire local counsel. Local counsel does nothing but sit down at the court all day long with the judges, and they become fairly buddy-buddy. And so, don't be too shocked if they're referring by each other by first names or whatever, and just don't be concerned about it. It's just going to happen. So that's how it is, all right, just so you know. So they're going to have the opportunity to go through it. You make your best argument that you can, and you tell them exactly what it is. Judge, they don't have an acceleration notice. And he's going to say, too bad, whatever. And they're going to say, Judge, they don't have an endorsement. Now, what they should say is, well, that's a problem. Mr. Plaintiff, what are you going to do about that? But you just make that argument as best you can, okay? Now, if you lose, and ask for 30 days to answer, and that should be granted, and you go on. Another way that this could go is you do it in chambers, all right? And chambers is basically kind of a room like I'm in right now. It's kind of a bigger room, usually with a conference table. The judge would normally sit on one end of the table. There's usually a deputy sheriff in the room, make sure no one's doing anything to the judge. Sometimes there's an assistant for the judge, the judicial assistant like we talked about. And then you go in with the plaintiff's counsel. Usually you sit on opposite ends of the table, so you're kind of facing each other so you can square off. And then we're going to do the same thing. So instead of being in court, you're in this this room we call the chambers. So you want to find out before you get up there, are you in chambers or in the court? And you can ask the court personnel when you get there where the case is. The notice of the hearing should tell you exactly where it is. All right. So it's going to work the same way either way. Now, let me tell you one more thing too, which is probably the plaintiff's attorney is going to take care of this for you. But you should know the judges sometimes sign the orders and sometimes they don't sign the orders. And sometimes they do what, they'll sign the original for the court file, but then they're going to say, hey, the conforming materials are over there. And you're going to say, what the heck is that? Well, it's just a stamp for the judge. And so if, if the judge says granted or denied, then they'll sign the original, and then they're going to want you to stamp the orders that you have. Now, we have sample orders in the materials as well, so either way. But probably the plaintiff's attorney is going to have the orders there one way or the other and take care of it for you, okay? But just so you know, I just want you to know, so when you're walking around, you know all the terms and how things work, and you don't, look too bad. So conforming just means that you're putting the judge's signature with a stamp on the order when the judge doesn't sign it for you, okay?